Let's get on the record in 24 SC 005283, which is State versus Thomas. Mr. Thomas is here in court with his lawyer, Mr. Slayton. We have Ms. Davis for the state, and it's my understanding, Mr. Thomas, that you're prepared to enter a plea in your case. Is that correct?
Correct.
All right. Ms. Davis is going to put you under oath, ask you some questions. You need to answer those truthfully. I may have a few questions. You need to answer those truthfully as well, and we'll see where that takes us. Ms. Davis, when you're ready.
Mr. Thomas, please raise your right hand. Do you swear or affirm the testimony that you will give in the matter before the court should be the whole truth and nothing but the truth? You can put your hand down. Please state your true, correct, and legal name for the record.
Jarrell Thomas.
Are you at this time under the influence of any alcohol, drugs, or medication?
What's that?
Is there any medication that you normally take that you have not taken today? How old are you and how far have you gone in school?
36 years old. I graduated high school, attended some University of West Georgia College.
Where did you attend high school?
Here I was in high school.
Are you able to read, write, and understand the English language? Are you a United States citizen? Do you understand that you're charged with the following offenses in indictment 24 SC 005283, aggravated assault, riot in a penal institution, and possession of a dangerous weapon? Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your lawyer, Mr. Slayton, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney? Are you satisfied with his services?
Great guy, yes.
Attorney Slayton, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes, I do.
Mr. Thomas, do you remember having been arrested on these charges?
Fortunately, I do. Yes, ma'am.
The state is unaware of any outstanding warrants related to this matter, Judge. Attorney Slayton, are you aware of any outstanding warrants related to this charge?
No, I am not. There is an issue that we spoke about earlier. There's a kind of a floating battery charge that has another case number that's in a pre-indictment status. I'm not sure if it's connected to this case or the prior case with Detrell Wimberly. But I'm not sure if that's real or not, but that's not, but no active warrants I'm aware of on this case, no.
Understood. And Judge, we will address Mr. Thomas's second case at the end of this plea colloquy.
Right. There's a case ending in 460. That's part of what you all have worked out?
Correct.
Okay, great. I'll make sure we cover it.
And so when you pull it up on Odyssey, there's three open cases. There's this one, the one that ends in 4460, and then there's another case that's in between those two, I believe, which is just a battery charge. And I'm not sure where that comes from.
Well, one, that would be a misdemeanor, so it would be in state court if it's going anywhere.
What I saw, it was referred as an unlawful act in a penal institution, and I wasn't sure if it was upgraded into this case or the 4460 case.
Do you have the PI number for it? Because I can look at it while we're talking.
I do, Judge.
Okay.
It's 24 PI 005509.
All right. I'll take a look at that and see what I can find out about that.
Thank
Sure.
you, Judge. Mr. Thomas, has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court? Do you understand the court is not required to accept the state's recommended sentence? Do you understand the court has the right to sentence you to the maximum possible sentence on each charge? Do you understand that there are multiple charges to which you are pleading to today, and the court has the right to run those charges consecutively or one after the other? Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts? Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else? Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence from 1 to 15 years in prison? Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're given up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself, the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? How do you plead to the charges in indictment 24 SC 005283 to count 1, aggravated assault, count 2, riot in a penal institution, count 3, possession of a dangerous weapon by an inmate?
Guilty, yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty? Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you? Judge, the state believes at trial we would show that on June 3rd, 2024 at 901 Rice Street in Atlanta, Georgia, which is in Fulton County, that the defendant was observed on a Vigilant camera footage removing a large club-like makeshift item from his pants and striking the victim, Mr. Manville Britton, repeatedly in a fight that took place in the jail. He was struck several times. The victim's jaw was swollen. He had a swollen eye. He sustained some injuries and was transported to Grady. This weapon is referred to as maybe like a makeshift kind of shaped type of a weapon. The state, in consideration of the resolution of this case, we are moving to dismiss 24 SC 004460. We are recommending to the court that he accept 15 months to serve. Of course, credited from the time that the offense occurred on June 3rd, 2024. We're not asking for any terms and conditions or probation because it's my understanding that the defendant will already be on a probated sentence. And so as opposed to having 2 probated sentences, he will already have probation in place. And so that is the terms for the court. And we have nothing further.
What's the sentencing range for riot in penal institution?
Roman judge. I believe it's a year, but let me just check. I want to say it's a minimum year.
6.
All right, let's talk about that. This hearing for Mr. Thomas had the weight and pace of a serious courtroom, moment no frills, no distractions, just a man taking accountability for some serious charges. Mr. Thomas, 36 years old and represented by Attorney Slayton, entered a guilty plea to aggravated assault, riot in a penal institution, and possession of a dangerous weapon by an inmate. The context? An incident that took place inside the Fulton County Jail on the 3rd of June, 2024, where surveillance footage showed Thomas pulling a makeshift weapon from his pants and repeatedly striking another inmate, Mr. Manville Britton. The blows reportedly caused significant injuries, including a swollen jaw and eye, and required the victim to be transported to Grady Hospital. From a courtroom management standpoint, the judge kept things on track. making sure Mr. Thomas understood every right he was waiving. There were no signs of confusion or hesitation. Mr. Thomas acknowledged his education levelsome college in, confirmed that he could read and understand English. His tone was steady, if a little subdued. He gave yes or no answers without resistance, even managing to inject a little dry wit when asked if he remembered being arrested on these charges. Unfortunately, I do. It was a moment of realism that didn't seek pity, just honesty. Miss Davis, speaking for the state, clarified that Mr. Thomas had 3 cases floating in the system, including an older one and a battery charge that might be linked to this same incident. But as part of the plea deal, one of those cases case number ending in 4,460 was being dismissed altogether. That likely made a big difference in how this deal was structured. Now, about the plea deal. The state recommended 15 months to serve, with credit for time already spent in custody since the 3rd of June. There was no request for probation, as Mr. Thomas was already serving a probated sentence elsewhere. In other words, this was about closing one chapter without unnecessarily stacking up overlapping supervision. Clean, contained, and enforceable. The courtroom stayed calm throughout. No dramatics, no resistance. Even with multiple case numbers floating around and legal housekeeping to sort through, everyone stayed on task. The judge even checked on the sentencing range for riot in a penal institution, verifying that it carried a minimum 1-year sentence before moving forward. What stood out here was how efficient and focused the hearing was. Mr. Thomas owned up, his attorney stayed sharp, and the judge gave the whole thing a sense of structure without being robotic. It was clear this wasn't Mr. Thomas's first interaction with the system, but it also wasn't a case of the court going through the motions. Every step was double-checked, every right acknowledged. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.